And the first trend was the Supreme Court. Its decisions, at least in the workplace class action world, are the key driver of risk and what are called bet the company cases. It, in essence, drives litigation dynamics. Some think the court or characterize the justices on the court as pro-worker. Some say pro-business. Some say pro-class action. Some say anti-class action. In my mind, I think the analysis is a little more nuanced and anything but one-dimensional. The way I view it, at least in the practical trenches of the litigation world in that I live, is cases are either courthouse door openers or courthouse door closers. They either create barriers or they eliminate walls that allow litigants to get into court. They are either sharp and well-defined, or they have a gray area, and God knows when lawyers encounter a gray area, they can wreak havoc on some of the issues at hand. But I'm often asked, of the 1,300 cases that are reviewed in the book, what are the two most critical decisions? They're right here, the Tyson's Food case and the Spokio case. The Tyson's Food case, I think, has a lot to do with risks that corporate America will face in 2017. Vicki had mentioned the seminal Dukes v. Walmart case from 2011, published in the Wall Street Journal the day of the decision. This changes the dynamics for companies, makes it much harder for workers to sue, to band together, to bring class actions and successfully prosecute their cases. That decision still is the 800-pound gorilla in the courthouse in 2016, cited in over 600 cases. Truly, lawyers, companies have to come to grips with what Dukes v. Walmart means in the world in which corporations find themselves litigating these bet the company cases today. But Tyson's Foods opened the door and created a workaround for the plaintiff's bar, in my mind, that makes it easier for them to certify cases, easier to create the conditions for opportunistic settlements, and will be a driver of litigation risks. In essence, it opened a door that Dukes v. Walmart closed. It in and of itself, even though decided in mid-year of 2016, is cited over 100 times by courts around the United States, encountering now new class action issues as a result of these new guidelines, these new field goal posts that have been created by the Supreme Court. The other big case was Spokio, also an employment case about onboarding or hiring and having to do with the concept of who may sue and what may they sue about in terms of these laws that Congress allows workers to sue, not necessarily because they have a pocketbook injury, but because there's a violation of statutory law. Very gray, hard to figure out, door opener, lowers the barriers. It's cited over 360 times by courts, and I think in the 6 months since Spokio decided, we've seen a lot more cases in this particular area and has generated more cases. So my prediction for 2017 is lawyers representing workers will be citing these two cases, relying on these two cases to try and ring the bell and create opportunistic conditions to settle.